admitted long back lordship in the month of bail, but for the consideration of bail, government has
problem.
filed.
May please, Your Lordship. But you have mentioned for an interlocutory application. For tomorrow, it's a modification we seek for tomorrow. Obliged.
Yeah, please, Your Lordship. I have to mention for list one I on third Lordship. Obliged.
I like to mention item number 6, the daily list. Kindly pass over the matter.
Where is the cause list? Where is the cause list? They have not given me. No, my copy. Okay. Today also I had seen it. Item 6, you have not made a prior application, I think. Have you made? No.
We have
No
consent
prior
from the other
application.
state. We have taken consent from the other
They
state.
say they have taken consent.
They have taken consent, but they are supposed to make a.
Yes, 5 on
application, I think.
adjournment slip beforehand.
Item 6. Why?
My senior is out of station.
Where is he?
My senior is out of station.
Where? Where is he? In London? Where? Out of station where? No idea.
She's the one on the last one, she made a mention, her senior is in lower court or something like that. I made her understood, not to
And
submit.
now you don't know where he is. Missing. Do you believe that we believe you? That you don't know where he is? Just give me item 6. Let's see how many times she has taken adjournment. You see, madam, as per the notification issued by the High Court, if you want to take adjournment, you have to give prior notice in a form like this. Okay, like this. Last court date, none appeared. Okay, none appeared. Right. On the prayer for adjournment made on behalf of Mr. A. Raman, learned counsel for the appellant, which is not objected to by Ms. D. Duyan, additional PP, list the matter. After
2 weeks.
2 weeks.
Yeah, please. I recommend item number 2, madam.
Item
Item number 2, madam.
2.
We are not,
Yes.
we are not prepared, madam.
Huh?
Today we are not prepared for this matter, madam.
2 is connected with 3. She
Who is connected with 3?
My lord, I am production, my lord.
What is your prayer?
My lord, I want to, because I am, my lord, the appellant's mother, my is a cancer patient, is the only son. And when this appellant, my lord, entity number 3, they are near about just close the 18 months.
So have you taken his consent?
We have asked for the consent.
But
He has
Sir
not
says
given.
he will do the case, madam. But we are
He will
not
do the
prepared.
case. He has not given consent. Now what to do? You are always asking for time.
prayer, my learned friend is not, my lord, prepared. In my case, bail prayer may be considered my lord. Leaving the my lord criminal appeal, my lord, because there is a specific order, my lord. If there is a delay of hearing, the bail is got to be considered, my lord. It is last in 2021, it has been passed, my lord.
When are you ready? Just give us this item 2. The problem is item 2, they have given a prior information.
My lord, yesterday also they, my lord, asked for my lord, consent, my lord. I said that I only pray for bail, my lord, that my.
You are always asking for adjournment. Huh? Cannot be allowed all the time. On your prayer, You're for Mr. Mahajan.
Yes, ma'am.
1, 2, 3, 4, and 5 times. Why should we allow?
That's it, give it 1 week time, ma'am. We'll be prepared.
Huh? Tomorrow?
After 1 week, ma'am.
Why?
Next week.
Why? Okay, right. Mr. What is your name?
Dibora, ma'am.
T. Bora.
Dibora.
D or T?
D.
D. Bora. Appearing on behalf of Mr. Yes, the council.
Yes, Lordship. H. Chaudhary.
Appearing on behalf of Mr. A. Chowdhury, learned counsel for the appellant in criminal appeal 135/2020. Praise that the matter may be adjourned. Why could it be adjourned? What ground?
We are not prepared, ma'am.
Huh?
We are not prepared, ma'am.
Yeah,
Because we
that-
are not
Prepared.
prepared. Not prepared.
On the ground that they are not prepared. Full stop. It is noticed that this case has been adjourned 5 times on behalf of the counsel for the appellant in criminal appeal 135/2010. As the adjournment application has not been objected by the additional PP Ms. S. Jahan. The this matter, on the prayer of the counsel for the appellant on after a week. So no further adjournment will be given. Huh? No, for suggestion, let's say the counsel for the appellant submits that no further adjournment will be prayed for by the appellant. This is the matter after a week. Then in item 3, you are in item 3. Item 3, you want to hear the bail application. You wait. The item 1 is there also.
Item number 7, madam.
Item 7.
7, madam.
Yes.
I have
Yesterday,
given adjourn.
Okay, right. On the prayer for adjournment made by Mr.
M.A. Chaudhary, madam.
M.A. Chowdhury, which is not objected to by Ms. B. Buyan, additional PP. This is the matter after
3 weeks, madam.
3 weeks.
Item 1, here your lordship wanted me to bring the FSL, the examination, if any, of the accused garments and all. But then I had sent the letter along with the order and all, and then I had sent my person from the PP office to the FSL office. They did not accept, and they said that I have sent the report to the registry. But then I don't find any report in the registry. They didn't accept my letter saying that we have sent. But I've checked the records, they have not sent. So lordship, we don't know, they have returned. Perhaps they are talking of some other, because there is another FSL report which I have asked for. So lordship can either hear the matter or direct the registry to do it. I don't know, they did not receive my letter. Things are destroyed, it's written in the judgment, but then they said I have sent, but it's not there.
So where
There's
is your,
another-
let us see your letter.
Lordship, oh,
Where
it's-
is your letter?
the letter is there in the office. If your lordship takes it up after some time, I'll bring it. They have kept one copy in the office
So your letter is to what effect?
to
To the FSL.
to the FSL saying that if the
This is
things are there,
spermatozoa match.
whether they match,
And whether if the article is not destroyed.
if the articles are not there.
So what is their reply?
They had sent the person back and saying that we have sent it to the registry,
Send what?
but send the report, whatever report, they did not say what it's written in the report. They said I have sent it to the registry, but it's not there. One more matter where lordship wanted another report as far as the signature or name is concerned, there is an overwriting. Perhaps they talked where they spoke of that. I'll have to clarify, or lordship can directly
I
registry.
think better to clarify or what, I don't know.
Clarify that, or registry, they did not.
No, let us see, no, did they give you oral reply or was
They
it
had
written?
sent the person back from the gate of the office, the first room of the office itself. I had sent 2 letters regarding that
Please
and the
produce the
other one.
letter, please produce the letter.
Letter is
Then-
there in
Then
the.
we can at least pass a meaningful order, otherwise
I'll bring that,
it won't
I'll-
be complete.
yes, I'll bring that letter within a hour or so, with, after some time.
Is there any paper book out here?
My lord, paper books there, my lord.
Give me one. Oh,
Paper book is in item 2, is it?
My lord, same paper book, my lord.
That's what I'm saying.
My lord.
It's in item 2.
Repeating for it. বাবা, মই বিচাৰি আছো।
long time.
নহয়, মই- ৰবা, ৰবা, মই-
This is a matter under 302.
My lord,
Uh-huh.
302, my lord, my lord. In fact, my lord, 30 is not established, my lord, that this relative appellant has committed any offense under 302, my lord. Rest, my lord, whatever other section, my lord, 147, 341 and 3.
We
Yes,
have,
suffered.
we have to go through this entire thing. As
My
good
lord,
as,
lordships, only,
it'll be as good as hearing the appeal.
my lord, only 4, my lord, witnesses, their lordship may present the 4 witnesses, my lord, that evidence, if lordship is satisfied, my lordship can pass an order, my lord, appropriate order. my lord.
If we are satisfied, we'll pass an order. If we are not satisfied, also we'll pass an order. It's not that-
Releasing, my lord,
It's not that,
Allow me to go on bail,
it's
my
not
lord.
that, it's not that we can pass an order only allowing the bail. It
My
can be otherwise.
my lord. Yes, fair point.
Perhaps I filed my objection here, Sarlongri, no, Teron,
Mm,
Sarlongri, Teron. It was a long time, long back.
Lordship may
Just-
come to
just-
paper
just
book
a-
1, my lord, paper book
Just a
1.
minute. Let us see if your written objection is there.
I am so sorry.
Yes, it is here.
His father's evidence would be generated.
Yes, কোন আর এই পিটিএম পিটিএম কোন আর এই অবজেক্ট কোন দিয়াটো তাই মই বিচাৰি পোৱা নাই Lordship may come to paper book 1, my lord. They are
I
fireable.
think you will take a long time.
Mm.
129 witnesses.
Of course, father's evidence is the most relevant and
Father, my
is
lord,
personal.
then one Bonolota, my lord Chaudhary, then one Maguram Boro police, and my lord Deka, and Ratul Das, my lord. These 5 are important. Then another OC, my lord, is a Duora, my lord.
Okay, let us go to the FIR.
FIR, my lord.
Page.
Page
4.
8, my lord.
Page 8.
Paper book 1, my lord. What way is it? More তাতে নাই।
Yes,
May I please lordship, my lord.
yes, you,
May I read, my
you give this to Ms. Jahan. She wants the written objection.
Because I lost it long back. Obliged lot.
May I read, my lord.
Yes,
With reference to the subject cited above, I have the honor to inform you that on 25/6/2013 at about 6:20 PM, while I was out of the outpost, I had been informed. Lordship, sorry, I'm reading different ones, lordship, sorry. It is a second FIR I'm reading, this is a first FIR, my lord, page 3, my lord. Page 3, my lord.
yes.
I have the honor to inform you that following facts for your needful action that, sir, today, 25/6/2013, I was traveling with my son within bracket Jankar from Difu Law College or police to police point near head post office by the auto rickshaw at 5:55 PM bearing registration number so of which return fare is at 10 rupees each, totaling 20 rupees. 2. The driver of the auto rickshaw refused to accept the legitimate fare, rather used to abuse and foul languages hampering our dignity, which my son also mildly protected. At this point, me and my son, Shankar Soikia, tried to avoid the unwanted situation, but the said auto driver with some of his colleagues attacked us from behind, blaming my son as an extremist, which was followed by open torture of my son and me for an hour. The above assailant dragged me and my son used to beat us brutally with an intention to kill my son, which started from first police point near post office to town post office, covering the distance of about 600 meters. My son is admitted in the Dikhut Civil Hospital in a juncture to file and whose death immediately sophisticated treatment is required for multiple injuries to receive. Now, Your Honor is requested to ensure the safety and security of my son and my family forfeit. And at the same time, Your Honor is earnestly requested to book the culprit and to initiate an exemplary action against the assailant, for which I shall be remain forever. My lord, here FIR in the my lord, nobody was mentioned, but here my lord, in my lord, paragraph 3 of the FIR, my lord, the auto driver and some of his colleagues who are the attacker is the auto driver, where is the dispute between FIR and his colleagues. So we are not in his colleagues, the appellant here in my lord. They are the students. They are luckily on that day in the market, my lord. Unlikely, my lord. Not luckily, my lord. Unlikely in market, my lord. So we are not auto driver, my lord. He is specific. We were the assaulted him. Those are auto driver or belong and his colleague. That means auto driver. Others are auto
Doesn't
driver.
have to be auto driver, it can mean anything.
My lord,
Either-
his first impression.
He's just speculating that's an auto driver. This is not evident. This is just the start
Yes,
of
I'm
a
indicating, my lord. His first impression is he might have been assaulted by the auto driver and his colleague.
first impression is a first impression. That's not proof of anything. Then next.
Then, my lord, she comes to para 4, my lord.
Para 4?
That FIR, my lord.
Yeah.
The assailant, whoever it is, my lord, dragged me and my son, used to beat us brutally with an intention to kill my son. We started from first police point near the post. There is a police point, my lord, that is a circle, my lord. There is a first police point, my lord. Town outpost covering distance of 600 meters. So, my lord, the town outpost, they are proceeding from that point. We were the assailant, my lord. They are taking them or him by his son, my lord, to the police outpost, which is, my lord, 600 meters in between, my lord, distance. So I mean, my submission is that there is no intention to killing. Maybe he has died later on, but there is no intention to killing as per the
But
FIR.
you keep on beating them. If you keep on beating someone, then what? Then you expect nothing, that there will be no effect with the beating.
No, my lord. I think the evidence says that they are taking to the police station,
Maybe,
but there is no intention to kill, my lord.
maybe no intention to.
If they have the intention, my
your
lord, then
case
he
is
not
what?
took him to the police station.
So is your case 304?
No, madam. 304 is not coming. Until and unless 302 is established, my lord. The murder is established, my lord. Then, my lord, come to my lord, evidence of my lord that according to the prosecution style witness number 93, page number, my lord, the complainant and the father of the victim. Page 127.
127 or 93, which one?
PW 93, page 127.
Page 127. PW 93, yes.
He is the complainant and the father of the victim.
Yeah.
May I read the my lord, evidence?
Yeah.
The incident occurred around 5:30 to 6 p.m. on 25th June 2013. I am the complainant of the case. I have recognized the accused person present in the dock. Here, my lord, he recognized for the first time in the dock, my lord, all the accused person. Out of that, my lord, the appellant, my lord, present appellant, they have been not, my lord, facing TIP, my lord.
There has not been,
Facing TIP, my lord. That I did not period, my lord.
but he has recognized.
Maybe, my lord, for the first time it did occurred in 2013. It is evidence on, my lord, 2019, my lord.
Maybe he still recognized someone. Someone who killed his son. Why won't he recognize?
My lord, here is 200 and 250 people.
So,
Anyway, my lord, I'll come to that part, my lord. At the time of the incident, I was residing near the Dipu Law College and was practicing in Dipu Court. On the aforesaid day at around 5:30 p.m., I, along with my deceased son, came to Dipu Market by an auto rickshaw. After reaching there, we got down from the auto near Dipu Police Point. After getting down from the auto, we gave 20 rupees, 10 rupees for each person as fare to the driver of the auto rickshaw. At that time, the aforesaid auto driver was accused Robinson Teron. Today, I have identified the aforesaid accused person in the court. I identified aforesaid accused person at the time of conducting the TIP in Dipu jail before the magistrate. A01 so was the registration number of the aforesaid auto rickshaw. The aforesaid accused driver asked for about 10 rupees from me after I have paid 20 rupees as auto rickshaw fare. At that time, as I did not have 10 rupees note with me, I proceeded towards nearby mobile research shop, saying the auto rickshaw driver that I would bring 10 rupees from the shop and gave it to him. Thereafter, I saw that the aforesaid accused driver, after getting down from the auto, started to shout in Karbi language. I do not understand Karbi language. Then I heard my deceased son, Jhankar Soikia, saying to the accused that he would pay rupees 10 as demanded by him. After that, the accused driver was saying, "Who are you?" Gave a punch on the neck of the deceased from behind. Thereafter, the accused driver got excited and said something in Karbi language. Then two Karbi community youth came to the place of incident. Among the aforesaid two youth, one was Sarlongri Terang. This is one of the appellant, my lord.
he is the other appellant. is it?
Applicant number 1.
And
My-
what is your name?
My lord, Sarlongri Terang, my lord.
Huh?
Sarlongri Terang, my lord.
He's the one. Oh, he will
Came
identify.
with the other two boys.
Huh?
Who came with the other two boys and he had beaten up the deceased along with the driver.
So
Who is the evidence?
the present applicant now is this Sarlongri.
Sarlongri, my lord. My lord. Among the aforesaid two is, one is that while the auto driver give a punch, my lord, it is according to him, he was also one of the person who was there, my lord. And the other one I have not seen today in the court. The other was not seen. The aforesaid two youth came there and started to beat my deceased son. I requested them not to beat. While the beating was going on, accused driver was talking over phone with someone. Thereafter, finding no way out, seeing accused Ramesh Chandra Nath and police officer Harun in the place of incident, I requested them to save the deceased from beating. Then the Harun Bora lifted my deceased son in the Tata Sumo vehicle, stand in the place of incident. Thereafter, I saw that approximately 30-40 persons of Karbi community came to the place of occurrence and tried to pull out the deceased from the vehicle. Then I resisted them, but they did not listen to me. Then on seeing pistol with accused police officer Ramesh Nath, I again requested him to take my deceased son away immediately from the place of incident in the aforesaid Tata Sumo. At that time, I saw one stick in his hand of the accused Harun Bora. I saw that instead of taking away the vehicle, accused Harun Bora instructed my deceased son to get down from the vehicle. Then 5-6 persons obstructed me and they beat up me. They were Mongol Singh Rongphar, Sarthebe, Binong Terang, my lord. These are one of the appellant, my
He's one of the
In,
applicant number
in this case,
my lord.
who are the persons? Sarlongri and
Sarlongri and Binong Terang.
No. He had also recognized that, identified. Binong Terang. Binong Terang.
Binong Terang, my lord. Jun Singh Terang and Sar Singh Terang, my lord. I have identified them being seen in the court. So today seeing in the court, my lord, he has identified for the first time. Thereafter, the accused person brought down the deceased from the vehicle and started to kick him. In order to save the deceased, I laid my body on him, and then they also assaulted me on my hands and legs. At that time, accused Dilip Teran, Bikram Tisu, Philip Santaro, Hitesh Rava, Biswajit Hanse, and Yunus Singh, who were present in the court today, assaulted my deceased son by removing his clothes, tried to remove underwear of the deceased, and shouted, saying as extremists. Thereafter, the accused persons present along with others started to proceed towards police station on foot by beating the deceased. Then I tried to stop the assailant by shouting. Then the accused Binong Terang and Yunus Timung dragged me to the side of the road.
Binong Terang, applicant.
They punched in me in my head by saying that I am the father of the disease. As a result, I lost my conscience and fell down near the bridge. After regaining my sense, I saw that at about 100 meters away from the place where I was laying, one police officer, along with approximately 150 people, taking my deceased son to the police station by raising commotion and assaulting him. Though the aforesaid police officer tried to protect the deceased, but he failed to do so. Accused Ramesh Nath did not use the pistol with him and his role was not active. At that time, the market was closed and I tried to proceed slowly towards TOP, and many people gathered there. Seeing the crowd, I did not enter TOP through its front door
What is
and
TOP?
the town outpost, that police outpost, madam. The TOP, two disease. After 15 minutes, one additional SP, one ADC arrived there. Recognizing me, they asked me that, Soikia, you have come to such a pass. At that time, I was not in a position to talk. Thereafter, they called an ambulance to take the disease for treatment. Afterwards, an ambulance came. My deceased son and I were taken to Dipu Civil Hospital. The deceased were admitted there and I was also provided treatment. The hospital authority advised to shift the disease to Guwahati for better treatment. Next morning, as per the advice, the disease was admitted in the Guwahati Dispur Hospital. On 1/7/2013, disease expired while undergoing treatment. Thereafter, the post-mortem of the disease was conducted in Guwahati Medical College. After that, we brought the disease to Difu. From there, we took the disease to our original residence at Titabar for cremation, and cremation was done there. I practiced near about 23 years at Difu town, and advocacy was my only profession. After the incident, I left Difu and started to live in Titabar. I have spent about rupees 3 lakhs for treatment of disease and me. I lost an Ejahar with Difu police station on the night of the incident. Exhibit 1 is the FIR, Exhibit 1-1 and Exhibit 1-2 are my signatures. Exhibit 1-3 is printed form of FIR. At the time of incident, the disease was studying in BA first year. The inquest of the disease was conducted in my presence at Guwahati. Exhibit 2 is our inquest report containing 5 pages, and Exhibit 2-1 is my signature. I could have identified the accused other person involved in the incident if they were present in the court. Now, cross part, madam. At the time of the incident, my residence was in Difu Law College land. Generally, from home, I used to go to the traffic point of the place of incident or buy an auto rickshaw. There was no altercation between auto driver and us over the auto rickshaw fare. That there was no altercation between auto driver and us over the auto rickshaw fare. The additional 10 rupees demanded by auto driver could not be paid. In the place of incident, I saw 2 traffic police near the traffic point at the time of incident. Malad, at the time of incident, Malad, this is a police point, Malad, there's a traffic police is there, Malad. They have, Malad, witnessed the incident. They are also, Malad, adduced evidence as a witness, Malad. I do not know the traffic police Maguram Boro and police constable Maguram Boro and Torondaga. These 2 is the 2 police officer, Malad. I know 2 police officer personnel, they were accused Harun Bora and Ramesh Nath. I did not see any other police officer in the traffic point except the aforesaid 2 police personnel. So, my lord, the PW 93, my lord, did not see that 2 police personnel who was at that time was available, my lord. So only he see that 2 accused police personnel who are got acquitted, my lord. This is not a fact that while traffic police Maguram Boro and police constable Torun Deka asked us not to altercation near the traffic point, I came from there taking alone the disease. The accused person whom I have identified in the court today are known to me from the day of incident. This is not a fact that the police recorded my statement 3 days. My statement were recorded on 1/7/2013 at Guwahati and 21/10/2013 at Titapur. This is not a fact that on 27/7/2013, police recorded my statement in my residence at Dipu. Except accused Harun Bora and Ramesh Nath, I did not know the names of the other accused person prior to the incident. At the time of the incident, approximately 5,000 people were in the footpath. I do not remember the day of the incident. The office court were open on that day.
Okay,
of the
let's go
incident.
to the next. There's nothing much.
110, he had named these three to applicants, 110. PW 110,
PW,
110,
page 110.
the
Does it-
police personnel.
That Ratul Kumar Das,
Ah,
I think.
Under his leadership, other police personnel also went.
Page
156.
156. Here for the comment.
My lord, the 156.
156.
May I read, my lord?
Yes,
The incident occurred on 25th June 2013. At the time, I was serving as constable in the Dipu Sodor police station. Around 6:30 PM on that day, the
no, go to
officer.
the relevant portion.
My lord, then my lord, indeed, pass for the last from fifth line, my lord.
Last,
Yes.
but fifth line.
Fifth line, my lord.
Yes.
I saw
Binong Terang and Sar.
accused Robinson, Sanjay Rangfar, Mongol Singh,
So out here, the two applicants are Binong and Sarlongri.
my lord.
These two.
Their name appears, my lord.
You
Here.
are present in the court today, assaulting Jhankar at the place of incident. Besides, I have forgotten the face of other persons. Oh, he is also saying 161.
Then which are the evidence?
My lord, then my lord, Lakshmi comes with the police officer, my lord. One second.
Page,
My lord, Maguram Boro. My lord, page 45, my lord, Maguram Boro.
page 45. Yes,
My lord, yeah, very short, my lord, read all, my lord. I know the complainant among the accused person. I know the ASI Ramesh Nath, the incident occurred on 25th June 2013. On the day of incident, I had duty from 4 PM onwards at number 1 police point, that police point, my lord, number 1. I saw complainant Horen Soikia and his son getting down from an auto rickshaw near me. Now I have forgotten the physical appearance of the auto rickshaw driver. At that time, I heard the auto rickshaw driver and son of Horen Soikia quarreling over a auto fare. At that time, the constable named Torun Deka. At that time, the constable named Torun Deka came near me and we discussed them from quarreling. Thereafter, the constable named Torun Deka made Horen Soikia and his son walk towards the TOP. At that time, a large number of people did not assemble there. After some time, the Torun Deka came back me and said that getting an vehicle coming from the TV, he met Horen Soikia and his son, boarded the vehicle. Thereafter, we again became busy in the doing our duty at that number of police. They have seen that, my lord, that some quarreling, but they have not seen that there are some assault and these two boys are present. That time there is no gathering, my lord. Where the first incident occurred, my lord. Next, my lord, Torun Deka, other police personnel, my lord, 46. I know the complainant. Among the accused person, I know only ASI Ramesh Nath. The incident occurred 25th June 2013. Among 4:30 to 5 PM on that day occurrence, I was on duty at number 1 point police. At that time, I noticed that complainant Horen Soika, his deceased son, and one auto rickshaw driver were quarreling in front of the mobile research shop at that place. At that time, I heard that auto rickshaw driver saying that he would beat them up. And then I, along with 18, that means my lord Maguramboro, proceeded close to them. Thereafter, I told them that if they had any complaint, they should inform the police station. On the same, and I made the complainant and his son walk towards TOP. And PW 18 took the other two persons away. Later on, seeing one police gypsy vehicle coming from TOP, I made the son of the complainant board the gypsy. At the same time, I saw the Tata Sumo police vehicle was coming TOP side and accused Ramenath and Harumbra were in the vehicle, and the state vehicle was driven by one of the guards. Thereafter, I brought the complainant's son from the gypsy and made him board the Tata Sumo vehicle. Thereafter, I heard that the complainant talking with the accused Ramesh Nath regarding the incident. Thereafter, I returned to duty at that number of point. So here, my lord PW 93 said that the Otowala give a punch and two boy also attack or assault his son, my lord. Here they are the who are the police officer in the duty, my lord, in the first point place where the incident have been occurred, my lord, regarding the dispute regarding the general office, my lord, auto care. They are denying, my lord, they have seen anybody have assaulted. But there is a, my lord, heated of actions or quarrel, they have specified both of them. They took, if any you have grievance, you come go to the police. Then we have supposed to take to the police, and then seeing a police FC, they reported the Somu, my lord. That's in the matter in the traffic point, my lord. There is no quarrel, nobody has assaulted his son, except, my lord, that punch given by the, my lord, that auto rickshaw driver, my lord. Then Lord may come to my lord, the 110, my lord, the PW 110, one Ratul Kumar Das. So he also said something, my lord. Lord may come to the page 156, my lord.
He has identified you.
My lord, my presence, I am not doing. There is 164 statement, my lord. Everyone agrees. This is not under the provision of law. This is not a one. But even there, we have also category stated. We were there. This is a marketplace. We are onlookers. It does not mean that somebody said, my lord, without corporation, that I am also involved, my lord. Where is the specific statement?
Why is there any enmity between you and those persons that the maker of the testimony?
My lord, individual enmity may not be, but there is a, my lord, what to say, my lord. My lord, because, my lord, the word uttered by the boy, my lord, that Karbi, when we will shoot you Karbi people. Maybe due to this, there is a immediate enmity between Karbi and non-Karbi. That is there in the, my lord, judgment also. This is a racial classification, my lord. Maybe he is targeting who are in the dock, that they are my.
Who is this
So,
person?
but in the place of occurrence, nobody identifying. All are identifying in the dock, only 2%. This is not corporative, my lord. And what kind of part I have played, my lord, in the commission of what is there, my lord? Suppose they have identified me, my lord. Okay, how they have
The
where
father-
149 they have proved, my lord. There is a common object. I am party to the common object.
Well, carry on. You're not allowing us to question you, so.
My lord, sorry,
No, carry
sorry,
on.
my lord.
No,
Sorry,
no,
my lord.
you finish your part, we'll do our part.
My lord, lordship, lordship.
Anything else?
My lord.
Anything else?
My lord, only thing is this, my lord, the 149, I have been robbed with 149, man, by 149. Whether, my lord, 149, I can be robbed with the, my lord, this commission of 302, might be somebody have commit, my lord. Whether I have the, my lord. Other offense, my lord, that may be, my lord. One, the ingredient of others, but ingredient of, my lord, the roping with the 149. May I read the, my lord, 149, my lord?
Read it.
I have the most knowledge of the common object, my lord. And it is to be proved by the prosecution, not by me. They failed to prove that I can be robbed with 149 for the commission of the 302, my lord. Lordship. Lordship may have the chair, please.
Yes, carry on.
My lord. 149, every member of unlawful assembly guilty of offense committed in prosecution of common object. If an offense is committed by any member of an unlawful assembly in prosecution of common object of that assembly, or such a member of that assembly knew to likely to be committed in the prosecution of common object, whether, my lord, there will be a killing, there will be, my lord, I have the knowledge, my lord, the common object, my lord, likely to be committed in the prosecution of that object, every person who at the time of committing that offense is member of assembly is guilty of that offense. So, my lord, the prosecution have to prove that the assembly wrongfully assembled is to kill Shankar Saikia, my lord. And that killing, I have the knowledge, my lord, the common object. Then I can be robbed, my lord. Whether prosecution has proved, my lord, that the assembly is to kill the Shankar Saikia. But from the police point, he has been taken to the police point number 1, he is taken to the town outpost, my lord, TOP, my lord. If they have the, my lord, object to kill him, they could have done something, my lord. But intention is, my lord, that object, I don't have the knowledge, my lord. Yes, I was the onlooker, I was there, my lord. But I was not involved in the commission of operation, my lord. This is a marketplace, my lord. That day also, my lord, market day, my lord. And it's a people, 5,000 people is gathering. And 2 to 200 people, he said that 2 to 200 people assaulted his son, my lord. In the crowd, my lord. There is a specific statement, my lord. Only thing is that, my lord, the PW 19 is only for the first time. That is occurrence in, my lord, 2013. He recognized me, my lord, in 2019, my lord. And at that time, I was near about, just I have crossed the 18, my lord. Appellant number 1 and 2, my lord, both of them, just they have crossed 18, my lord. For 2 months, one become major, on few months, one become major, my lord. So that my physical features and at 19, my lord, after near about 6 years, my lord, how he can identify me, my lord, if it is known to me prior to that. Even he did not see the policeman, the Maguram Boro and Torun Deka, my lord. So how he can identify the Saluri Terang, he was present in the giving feast to his son, my lord. Where the police who has interfered with that quarrel, who took them to the police station. Thereafter, some common people interfered in the way, my lord. In the first point, there is no quarrel, my lord. And 2 of them are absconded, my lord. While filing charge sheet, my lord, 2 have been shown to be absconded, my lord. And the PW 92 said that 1 I have not seen in the dock today. Might have he made know that person. Even then, my lord, if their prosecution, suppose assuming that they have proved that 149 is attracted to me, my lord, I have that knowledge of the common object. Then even where is my fatal blow, my lord? Who has caused that death?
Anything else?
My lord, considering this, my lord, age, my lord, and the appellant number 1, my lord, his mother is a cancer patient, my lord. Now his stage of recovery, only son, my lord. So, my lord, and consider their age and consider detention period, my lord. They are in jail last, my lord, 3.5 years, my lord. And my lord, all the other 3 penal provision, my lord, we have completed 6 months, 1 year, my lord. If, my lord, suppose, my lord, if my lord got acquitted, my all that period will be illegal, my lord. Because, my lord, there is scope of acquittal, my lord,
What to
because
do?
there is no evidence coming against me, my lord, who has made the fatal blow. Even if I am a member of that 149 also, I cannot be penalized, my lord, if I have not no knowledge of that, my lord, object, common object, and I have not made the fatal blow for which the disease died, my lord. The complainant signed that. That's why I'm concerned this aspect of the matter, my lord. We will be allowed to go and bail, my lord. Only we are in 3.5 years, my lord. If my lord could find anything, my lord, we are ready to face the rest of the period, my lord. And if my lord, suppose, my lord, we are acquitted, my lord, all the period of detention will be illegal, my lord.
Yes, madam.
Now, it seems the prosecution has not only invoked 149 to bring home the guilt of these two accused, but there are overtax, as Lordship had seen.
Yeah,
There are overtax as far as these two applicants are concerned, because under 149, overtax is not necessary if they share the common object with the other members of the group of the unlawful assembly. That would be enough. Here there are overtax. Father and 110 had said that these
Correct.
specifically, that these two persons are assaulted.
identified
They have identified,
by
100
name also.
they have named these two persons. So 149 is there. Apart from that, overtax are there. And
Overtax, what do you mean overtax?
Overtax means the action that they had done, I mean, while pursuing their common object. Overtax is otherwise not required under
Acha,
one.
overt act.
Overt act.
I was hearing it as overtax.
Oh, no, no, overt act.
Talking, what tax? What tax are we talking about? It cannot be income tax or something.
That is why I'm wondering, Lordship knows, it was my mistake, I couldn't convey it. So these their actions are writ large in the evidence of father and the PW 110. And other witnesses have stated accused persons in the dock had assaulted. So they were all in the dock. May not, they had not named them specifically, but they have insisted
Identified them.
TIP was conducted. They have all,
No, we are not facing TIP, my lord. The rest of the accused are TIP.
because they were already identified by the
Anyway,
father.
right, madam.
My lord, may I read one paragraph of the judgment, my lord, regarding 149, my lord?
Okay.
149, I've seen they have, the honorable judge has only considered two judgments. Yes,
My lord,
and
may I read, my lord?
Page 368, 400 what?
400, I've got 463.
463. No,
149 will not be attracted in the
Huh?
instant case. 463.
463. 463.
no, not
Then,
416.
My lord,
There is a flaw. There is no finding as the 149 is concerned.
480.
Where?
Second,
180,
second,
84.
463. Yes, sir.
তুমি কোথায় এখন 149 পড়াবা হ্যাঁ 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 এইটাই তো কইছো 463. But these are all quotations. They have quoted the judgments, but independent finding have not got. Only 187.
463.
That is the problem. You see, this trial court,
Yes.
they explain the law, but they don't apply it.
Then I was telling him, they have quoted,
Ah,
but no finding.
yes,
Finding only 187, having carefully gone through the facts of the case and the observation made in the aforesaid case laws, I find no force in the submission. That would not suffice. They need some independent
there has
finding.
to be a finding.
That's a flaw. In fact, I have few judgments where it is said if there is no finding, then the judgment stands.
No, there has to be a finding. You see, there are judgments with regard to conviction,
Mm,
not the conviction not being there, the word convicted not being there.
mm.
But that, I think we have passed a judgment, that is saying that that will not, that does not vitiate the prosecution case. If there is a finding to the effect that they are guilty of the offense
Ah,
under so and so section,
Yes.
so that will take care.
That
Because
word
the
may not be
conviction is based upon the finding.
there. Uh-huh.
So,
That is okay.
so that technicality will not, but if there is no finding and there is no conviction,
Mm,
then becomes the problem.
Then become. Here also.
And out here, there is now whether there can be a conviction without a finding.
Mm.
That is also
Finding
another issue.
149 has to be there. That we will see during the time of hearing,
Yes.
maybe we take out something.
So, so in that aspect, maybe they can have something to say with regard to 149.
Yes.
But then that does not take away, I think, the power of the appellate court
Mm.
to come to a finding
Mm.
with regard to whether 149 would be applicable or not.
Or not.
But that will, we'll decide that at the time of appeal, final hearing of the appeal. But as on date, I mean, as of this stage, We shall have to decide on whatever is here.
Because the acts are mentioned, we may not go to 149.
What do you want to?
My lord, I want to. May I read one paragraph of the judgment, my lord? It is judgment of my lord. Modern Singh, my lord. Modern Singh versus State of Bihar, my lord. It is reported in my lord.
Which
2000.
page? Which page?
My-
Which page?
I provide a copy. sir.
No.
Yes, I'm reading the relevant paragraph, my lord.
You read the, we don't need,
My-
we don't need to go.
Section 149, my lord.
Yes,
IPC consists of two parts. The
those are
first-
all here.
My lord, this is judgment, my lord. The
These are, you think that this is not from a judgment that has been
No, my lord, this is
reflected
one
here?
judgment, my lord.
Yes, please read. Okay.
The section 149 IPC consists of two parts. The first part of section means that offense to be committed in prosecution of common object must be one.
Please
which-
come to page 463, the same thing you're reading. 463, page 463 of the paper book. Please read. Madan Singh,
My
the
lord,
state of Bihar.
but it's wrongly
2004.
interpreted, my lord.
No, 463 of the paper book. It is here. Para 185,
My
it
lord.
is here.
That is in my favor, my lord. In my favor, my lord.
We'll see all that.
These are
Just
in that
referring the
facts.
judgment.
These are in that facts.
These are on the basis of the facts therein in that case.
Right.
Now we have to see whether the facts herein
Right.
are similar to the facts in that case. You see, as you know, a judgment passed in one case cannot be applied as a Euclid's theorem in another case.
But ratio have to follow, my lord.
Ratio depending, it's an authority. See, decision is only an authority for what it decides, depending upon the facts and circumstances of the case in hand. It cannot be used as a precedent if the facts and circumstances are different in another case. A little difference in fact makes a lot of difference.
My lord, regarding interpretation of 149, my lord. we have to follow, my
Interpretation
lord.
of 149 will remain the same,
Whatever
no doubt.
interpreted by the
But
Honorable Supreme
we
Court,
have
my
to
lord.
see the facts and circumstances of each case. And as on date, whether 149 has been wrongly applied or not, that issue okay, we'll go into. But the question of you beating up the deceased and the deceased having died is shows that you were involved
But
in the
however,
assault.
where the specific statement, my lord, I have assaulted. He has assaulted
110,
blindly.
110.
No, maybe 110, but you have to specific now.
One witness is enough, Mr. Counsel. You don't need
No, my
20 or 30 witnesses. You have got to show that this witness, 110, is not a reliable witness. There may be contradiction. Triumph Maruti case, use that.
Contradiction is there, my lord.
Then you have not shown us the contradiction. Right. Right, Mr. M. Sarane, Learned Counsel for the
We are only in the, my lord, we are
applicant. Also, applicants. This is in IA 136/2020. And Ms. S. Jahan, Learned Counsel, there is additional PP. Post have also heard Mr. A.K. Hussain, Learned Counsel for the informant. Post up. This is an application under section 389 CRPC for suspending the sentence passed in pursuant to the impugned judgment. Impugned judgment dated
28.
impugned judgment dated 24/2/2020. And the judgment dated 2020, passed by the court of the
Session Judge.
Special Judge
Deepu Karbi Anwar.
Difu Karbi Anglong in Sessions case number 59/2018. By which the applicants, appellants, along with others, along with how many others?
My lord, Nine others, madam. We are madam two, but along with nine others, 8 others.
Along with 10 others were convicted under section 147/341 /323/302. Read with section 149 IPC. The applicant's counsel submits that the one of the applicant's parents' mother is a cancer patient, and being a single child has to look after the mother. He also submits that the applicants had just turned 18 when the incident occurred, and as they have been in incarceration for a long time, they should be released on bail. He also submits that the evidence does not show that the applicants could have been convicted under section 302 read with section 149 IPC. And as such, the applicants cannot have been saddled with the effects of section with the provisions of section 149 IPC. He also submits that it is unlikely that the witnesses could have identified the applicant 6 years after the incident during trial. He also submits that the testimony of prosecution witnesses number 18 and 19 does not show the involvement of the applicant on the assault allegedly made on the deceased. Okay, accordingly submits that the sentence should be suspended and the applicants should be allowed to go on bail. Puspa. Ms. S. Jahan, the additional PP on comma, and Mr. A.K. Singh submit that the evidence of PW 93 and PW 110 clearly show that the applicants have been identified by the prosecution witnesses amongst the number of persons who had assaulted the deceased prior to his death. As such, the proof of the involvement of the applicants having been recorded in the testimony of the above witnesses, the bail application should not be allowed. Next paragraph. On considering the submissions made by the counsels for the parties, we find that PW 93 and PW 110 have categorically named the names of the applicants herein as the persons who had assaulted the deceased who had subsequently died. As in view of the above reason, we are not inclined to suspend the sentence at this stage. The bail petition is consequently dismissed. Then you write in the main case, this matter in the next, after the week. you have to-
Paperwork is ready.
As paper book is ready. Okay, we'll, after 2 minutes, check now.
My lord,
Dated 20/01/2016. Issued by R. Bora Handik, Scientific Officer, Serology Division, Directorate of Forensic Science, Assam, Kahalipara. In connection with Samaguri PS case number 472/15 under section 302 IPC, read with section 4 of the POCSO Act. A registry to communicate the order and inform the and direct the and inform the director FSL Kahalipara to comply with the order or give reasons, if the same cannot be complied with. List the matter on when? After a month? List-
Specifically, it's a date, otherwise the registry.
Okay.
Huh.
List the matter when, give a date. After.
7th September.
Okay.
Up-
7th, make it 11th.
11th. That letter will be part of the record or what my,
You keep it, I don't know, it can be part of the report also.
it can be kept.
Can't get- Madam, we just write one thing. It said the letter dated so and so, that issued by the additional PP be made a part of the report.
My application.
Item 4.
For hearing.
POCSO.
So it's a imprisonment for life, madam. This behind the curtain.
Senior colleague will definitely give a chance to give a reply. Because Lordship, I will not, probably I may not be also able to complete it thoroughly today.
Oh,
Because there
why?
are a lot of witnesses. And I will have to, since I have been
How many witnesses?
convicted, I will have to satisfy Lordship that
How many witnesses?
they have relied upon 12 numbers of witnesses.
12.
12.
12 is not much.
Then if your Lordship allows me, let me
Only
start
there is only one problem.
Lordship.
We don't like doing things in parts. I listen to you now and then I listen to her after a week or after 2 weeks. That cannot be done
Then I will leave it up. to
because you see the
convenience
problem
of
is
my
that
court.
we forget also.
Then I will leave it to the
And again, we
convenience
have
of
got
my senior
to
colleague.
go through the whole exercise. We're wasting time.
Lordship. Then I will leave it to the convenience. of
Any
my
day,
senior
any
colleague.
day, only that I prepared series does and I thought Lottie will take up that other writ matter today
In that
for the
case-
entire day.
In that case,
No,
Lordship,
actually, there was, the problem is now the bench has changed
That I took.
and
can it be?
this is
Lordship, that
this
there-
Justice Nandi has now been given single bench also.
Yes, yes, it
So
happens.
now there's a problem. Now we cannot, he has got to do a single bench.
Yes.
That is the problem.
So any day, tomorrow, day after, any day.
Tomorrow, day after tomorrow, I some person inconvenience. Tomorrow I can do it. Tomorrow, if the Lordship permits me, I can do it tomorrow.
Tomorrow, it is already fixed, I think. Already cases will be fixed.
Well, Lordship, can it be like this, Lordship? Can it be,
No, what is your basic case? 660 kgs of ganja.
but Lordship 660 kg of ganja,
Ah,
but not seized from his possession? That I want to satisfy. In
seized from a vehicle. Or
No,
what?
It's
From
not
a
a
house.
vehicle. It's not a vehicle.
Ah.
Prosecution is contending inter alia that it has been seized from a house of the co-accused.
Ah,
Now, prosecution is trying to build up a case where prosecution is trying to show that this tank, it was seized from a tank, lordship, that this tank has been constructed by me. Now, I will satisfy your lordship that in fact the whole seizure is fictitious because they have examined two witnesses, Caesar witnesses, and when during trial, these two witnesses could not be found. EO has executing officer has come up with a deposition before the court that the name and the address given in the seizure memo of these two witnesses, they were not found in that locality. So seizure itself is doubtful. Then lordship will kindly see that here what has actually happened. NCB first came into that particular Mazbah PS with an information that some contraband is going to be seized and recovered. NCB did the whole exercise but left it to the Assam police. And then when NCB people were examined before the court, their evidence, if your lordship looks into, lordship will be, I'm certain that lordship will not be happy with their evidence. Because NCB, we all know, Narcotics Control Bureau, they are expert in this.
I don't know if how, what is their expertise. I don't know.
Anyway. So NCB is a dedicated bureau of the central government, which is investigating into this narcotic thing.
So?
So now NCB has also said certain things which are doesn't look so very clean.
Look, your submission is all around the bush. Go to the
No,
brass
I will
tacks.
come, then I will make a full hearing. I'll take your.
No, you can easily
All
say,
witnesses.
you see, you can easily condense your submission into 3-4 points.
And then lordship, his conviction has been mainly based on his own confession before the police during his custody. There are law laid down. If you forget that part also, if I just confine myself to Caesar and his confession, I think
Caesar made in the property of somebody else.
somebody else. And then
And that person has connected you with the
he
Caesar.
is also an accused.
Oh, has he connected you with the Caesar?
No, because
He has not, has he made any confession
no.
or
no,
any
no, lordship.
statement linking you to the, Caesar.
Rather, they tried to examine his wife. And his wife was a hostile.
then what is the connection between you and the property, the
No
contraband?
connection, lord. No connection at all. The property belongs to somebody else. Not from my locality at all. That is why I'm saying, lordship, nothing has been seized from me.
Other is convicted, other one is convicted,
Yes, both of them are from me.
both of them are.
And you are for one.
I am for one. I am
And
for
okay, now the other thing is, there were two persons who are convicted.
lordship.
The other person, has he filed an appeal?
No, I have no lordship.
Now that is a very relevant
I
point.
don't.
If he has filed an appeal, now we have got to see whether that appeal has been disposed of by this court or at what is the status of that appeal.
We don't have
Check
any
in
knowledge.
the
And
website.
other lordship will kindly see that I have been convicted under 27A, which says that I have been financing. But there is no evidence to show that I have
You have
been
been financing.
nothing to show.
Maybe you are the uncatchable big fish, maybe,
Yes. it
maybe
happens.
uncatchable big fish. Who is always around the radar, but no evidence.
Very clever.
So
Could be. So, but anyway,
What is
that cannot be a ground to,
Now, lordship, what has happened? Trial court did not find any evidence against me under 27A. So trial court has made me convicted under 22(2)(c),
22 B2C,
B2C,
22 B2C,
B2C. Commercial quantity.
commercial one,
And the seizure was made in presence of two witnesses whom
who
they
cannot be found.
cannot be found. The contraband was
And it was seized in another place,
in another place. Contraband was also not produced before the honorable court
under 54.
under 54. There are a lot of things out there. So I would like to.
So
address this
54A not complied with.
Not compliant. I'll address this honorable court with all this.
I'll look into that, and as far as the other convict is concerned, we can check it in the website whether he has.
Yes, that is the most
filed a
crucial. You see,
What is the
there's
name?
no point, it would be, could cause problems if we dispose this case
I appreciate. it.
and the other appeal is pending.
We
But
can check,
lordship,
what
we have
is the
checked it.
name of
We
the-
renewed
Ah.
personal registration.
Vinish.
RIUNU. I'll just tell you. the
It
name.
can be checked in the website.
It's not there, lordship.
Or not there.
না আমি চেক করেছি
You check, madam,
Huh,
you check it.
yes,
Otherwise, so that we don't have a problem later on.
yes.
So what we'll do is,
Renush. Lordship.
we have checked it lordship nothing is showing against it.
show me the, let there be some official statement or something
Lordship,
from the registry or something.
lordship.
Yes.
So that this is, because what could happen
Ah.
is supposing that there is some observation or finding made
Hmm,
in the appellate court against you,
yes.
or, you know, and then there'll be a,
I understand lordship.
And if
clash.
it is disposed of by now, then we'll also.
that,
I
that
will-
will also has, we'll have to
Ah,
see
yes,
whether it has been disposed of.
Lordship, only I
Yes.
will make one prayer that if we can do it little bit early because he is very sick. And it's on record lordship that 4 times he has been given interim bail by this honorable court on his medical ground.
Oh.
And he has come back already because he has surrendered. Now also
How old is he?
he is around 67, huh? 53 years old,
53, and he's,
highly diabetic lordship.
tell him to cut down on rich food.
He is anyway lordship will kindly see. Because all the medical records are on, medical documents are on record.
Ah. Anyway,
Renush is
that's on
also
the lighter
convicted.
side. Anyway, you see, we can fix this case, but then, let us have that report, only that. But it seems they've got the uphill task, it appears, as per his submissions, you seem to have an uphill task.
Yes, it seems,
you see.
normally the police personnel here, they don't know the procedures under the NDPS and they create all the problems. They do not follow. It happens. They don't take photographs, they don't take this and that. I mean, they don't enter the GD and they don't make the GD.
But
There's
that,
so many
but
flaws.
that might not be,
technical.
but that 54A might not be fatal.
But lordship, the important part is the IO filing the charge sheet. He made a very specific statement in the court during trial that nothing, no material is available in the Masbat PS, which we have investigated against him. He was involved, otherwise
Okay,
his antecedents.
Ah.
Nothing is there.
is IO,
I was given a statement during his examination before the trial court.
in the evidence.
In the evidence, it's there on record.
I'll see what I can find out.
So only on that point.
Can be. lordship,
Otherwise,
beyond
because
10
she's
or
not
11.
ready, that's why.
That's, I've not seen at all.
And
Then
because,
yes.
because of that, scrutiny has to be done with regard to the other person. Okay, right.
Can it be on 10th lordship? If it is
10th of?
convenient, 10th of August.
10th of August, yes, I don't know which bench will be sitting there.
Hmm,
I am
Then
going,
after independent.
I am going there after tomorrow
Acha.
to, I've got a meeting on Friday.
Oh,
So I thought next week also maybe I'll just be there. I haven't been there for a long time. So there's some work to be done.
17th lordship, if it is convenient for this court. 17th is a Thursday, it's a hearing day. Otherwise, I will leave it up to your lordship.
We can do it.
whenever lordship is back, wherever.
We can do it
lordship is sure.
anytime, 16th also we can do it.
16th is a Wednesday motion.
So how does it matter? Motion to doesn't take long in these.
As your lordship pleases.
Lordship will back in this week perhaps, so.
I'll be back on 14.
So
14th I should be
16,
there.
16, 17,
14, maybe, 16, 17.
17,
17th lordship, I
Thursday.
think it will be.
any day.
Which one?
Okay,
17th lordship.
right. Mr. A. Bhattacharya appears for the appellant, while Ms. S. Jahan appears for, additional PP appears for the state poster. This appeal has been filed against the judgment and order dated 26/11/2020, passed by the learned special judge Udal Guri in special NDPS case number 20/2050, by which the appellant Pradeep Jha
Pradeep Jha lordship.
has been convicted along with one
Renush Basumatari.
Basumatari.
Yunus Basumatari.
Renush Basumatari. lordship.
Just 61. Rinush, R-I-N-U-S-H.
Yes, Lordship, RINUSH.
B-A-S-U-M-A-T-A-R-Y. Basumatari.
For 15 years.
Under section
20B2C,
20B2C.
NDPS.
B will be small, 2 will be Roman small, C also small. NDNPS Act.
NDPS.
However, the present appeal has been filed only by Pradeep Jha. Full stop. In view of the fact that an appeal may have been filed by the co-accused, by the co-convict, Ms.
Rinush.
Rinush
Rinush
Basumatari, and disposed of by the appellate court, comma. We are of the view that an inquiry may be made, and we are of the view that the report may be made by the registry as to whether the co-convict Rinush Basumatari has filed an appeal against the judgment dated 26/11/2020 passed in NDPS case number 20/2015. If the full stop, if any appeal filed by the said Rinush Basumatari is still pending before this court, comma, the status of the same may be stated in the report. Full stop. Further, as Ms. S. Jahan, addition PP, prays for time to go through the case record, comma, list the matter on 17.
17.
17. Not 17, I think 16. Roughly, what is it?
16th is Wednesday, Lord.
Huh? Big man. Okay, 17. 17. Date.
Lordship, my only submission. My footing and Rinu's footings are entirely different. Because
That
from
may
his-
be.
Yes.
That may be. That's
what
not.
I'm living up to your Lordship, that may be kindly looked into.
No, you see, that's not the issue. The issue is if the appeal of the co-convict has already been decided and a finding has been made with regard to the testimony of the witnesses in that other appeal, in that, then that would be binding upon this court. Also.
Yes. But my submission will be Lordship may kindly not be from their judge, suppose any judgment has been passed by this honorable court. I also do not know, as an appellate court. But since the evidences are same, maybe same, but the footings are different, Lordship.
Maybe
that-
footing
that-
us,
that-
but then we cannot
so-
say that for considering that person's case, we have to consider the testimony in this light.
That's
For
what-
this,
that's what
it
I'm-
cannot, you
cannot
cannot
be-
blow hot and cold with the same set of evidence.
That will be taken
Otherwise,
care.
generally, there are some faults which I will definitely show to you.
In the GSC case status, I couldn't get by checking through the name. I couldn't get anything now.
Just
But
by way of
registry
abundant
will-
caution, and since you're not ready also,
Yes, I'm not prepared.
otherwise we could have heard the matter. I don't think it would have taken more than 1 hour at the most.
Yeah, 1 hour will be sufficient. I have some citations, including
1 hour for both of you,
Mhm.
not for.
Lordship has already dealt with these matters. There are some judgment of your Lordship only, which I can go to your Lordship and it will be very easy. Because those things are squarely covered in this case also. Deep level. এখানে এদিকে আছে।
Pokso.
Again, Posco.
It won't look nice. So when can we do it? Tentatively,
As per your lordship convenience, my lord. 22nd will be too long. Before that, my lord. 8th of August is that.
I won't be here.
Prior to 8th or,
I'm leaving day after.
okay, then when your lordship are coming back on,
I'll be here from 14.
okay. Then 22, no way out.
Okay. That supplementary item 1 and 2. List the matter on 22nd.
Obliged.
That's all.
164 statement is the basis for conviction.
Let us list it, when do you want? Next week?
Next week, date wise, it will be difficult for me to, because I will also be out of picture.
We cannot help it, Mr. Counselor.
Yes, my lord. Then, my lord, I am not pressing for any date.
Okay, right. On the, just list this matter in the next week. Give a date, any date, next week.
Obliged.